Hello, everyone. We're going to go ahead and get started. Welcome, everyone, to Center for Health Progress for today's webinar on public charge, new ruling impact on Colorado's immigrant and refugee communities. Today's webinar is sponsored by Asian Pacific American Bar Association of Colorado, Rocky Mountain Immigrant Advocacy Network, and the Asian Pacific Development Center of Colorado. Thank you for joining us. I'm thrilled to introduce our guests who will be our speakers today. We will be joined today by Roger Tsai, representing the Asian Pacific American Bar Association of Colorado, Caleb Stewart from the Rocky Mountain Immigrant Advocacy Network, and Harry Budisidarta, representing Asian Pacific Development Center. So first, I'm going to kick it over to our first guest, Roger Tsai. Roger is a partner and business immigration attorney at Holland & Hart and a member of the APABA, or Asian Pacific American Bar Association of Colorado. Roger counsels universities and companies in healthcare, technology, and energy sectors on securing temporary and permanent visas for foreign national employees, including H-1B visas and permanent resident status. He represents companies under investigation by the Bureau of Immigration and Customs Enforcement and helps companies perform internal audits of their employment eligibility documents. He leads the firm's immigration practice, which was recently recognized by Chambers USA as an increasingly strong immigration practice. Roger is an advocate on immigration issues nationally and a member of the Board of Governors of Colorado, and an organization that represents more than 10,000 immigration attorneys nationwide. Please join me in welcoming Roger today to share some insight on public charge. Roger?
Great. Thank you so much, Nicole. Hopefully all of you can hear me, and thanks for joining us in this sort of very unusual time. So today we're going to be talking about this public charge rule, and there will be speakers that come a bit later who kind of explain this in broader depth. I will mention, it might be on your mind, President Trump obviously had issued an unusual tweet on Monday evening, and then an executive order was signed on Wednesday, essentially kind of suspending the issuance of green cards for applicants who are applying abroad or essentially outside the United States. In short, it will have no implications or no sort of impact on the individuals that we're talking about today generally, as long as your clients are in the United States. So I'm going to just kind of talk about what's the relevance of this to you as an attorney that's perhaps practicing in an area outside of immigration. And then also the history of public charge in general, kind of what is the whole point of all of this? So this may be relevant to you if you are taking in clients, and you will want to think through, number one, am I dealing with somebody who does not have US citizenship, right? And so US citizens are obviously individuals who were either born in the United States, physically in the United States, or even perhaps a military territory, and also those who potentially naturalize through their parents. So individuals obviously can gain US citizenship through their parents. Typically they can be a green card holder for 3 or 5 years. The other sort of question I want you to think about is during the course of your client relationship, are you recommending or assisting your client with obtaining federal or local public benefits, such as TANF, SSI, SNAP, food stamps, Medicaid, or housing assistance, and specifically public housing, Section 8 housing, rental assistance? The reason why is that if they are receiving some of those federal or public benefits, that can have some sort of impact in their future ability to either, number one, extend their immigration status, or number two, get a green card. And so obviously that has large implications to the extent that you're not really quite sure either what their immigration status is, or number two, if the benefits that they're seeking may trigger some sort of bar in terms of future immigration green card benefits. Certainly you will, you can always touch base with a private bar attorney. I would recommend you reach out to one of the 200 American Immigration Lawyers Association attorneys. This is kind of like the ABA for immigration attorneys. And so we have a local chapter here in Colorado. There's roughly about 200 members. And you can search based on language, the type of case, and other things like that. There's a website called AILA, AILA lawyers.com that will give you up to, access to roughly about 11,000 of those attorneys. Just given the current climate, I will mention that sort of the application or receipt of unemployment benefits are considered a earned benefit. So that's excluded from the public charge implication. So in other words, if somebody's receiving unemployment benefits or the $1,200 check that was kind of distributed at a federal level, that does not have any implications in terms of what we're talking about today. Nor does the receipt of Social Security retirement benefits, Social Security disability benefits, or broadly, obviously, unemployment benefits. So I'm going to briefly turn over to these origins of this public charge rule. So there's the general thought is that when we permit immigrants to enter the United States, we want to make sure that they're not going to be a financial drain on our economy. So the Immigration Acts of 1882 and 1891 stated broad characteristics that would disqualify an immigrant from entering the United States. Most of these were physical or mental disabilities. There wasn't necessarily a, you had to have X number of dollars of income or X number of dollars of wealth. So the qualifications for becoming a public charge were primarily left to the officer's discretion. Next slide here. In 1997, so the INS published guidelines regarding an interim rule. And so specifically there was this form that was created. It's called an affidavit of support. And the rule was intended to hold accountable the sponsors or the family members who would sponsor a relative to enter the United States. So for example, if I as a US citizen married a Canadian individual, Canadian citizen, and I wanted to bring them into the United States, I would have to sign this I-864. I would have to disclose my income, any assets, and effectively I am agreeing for a 5-year period of time that once this person enters the United States, if that person begins to use any federal benefits, that I will reimburse the federal government for those benefits. And so this was, I would say, very loosely or rarely enforced. So in short, in my 15 years of practice as an immigration attorney, I have never seen the federal government actually pursue an individual and try to recoup sort of the benefits that an immigrant may have utilized. So it's kind of rare. But on the other hand, this is a really kind of unusual situation where, I as a US citizen spouse, even if I were to divorce that Canadian spouse, I would still be financially liable to support that individual, which has some interesting implications. So moving forward, in 1999, the INS at the time, so that's the old immigration agency, they had specifically excluded from this definition of public benefits that really mattered. They had excluded terms like Medicaid, food stamps, WIC, childcare subsidies, and other non-cash benefits. So the INS has since dissolved, and the Department of Homeland Security, and more specifically the US Citizenship and Immigration Service, that's a specific federal agency that's in charge of these immigration benefits. They have kind of taken over. So there's this form, once again, I-864, that adjudicators look at when they're doling out the benefits of a green card. And once again, it asks for income. I will also note that there's any person who is seeking permanent residency also has to go through a medical evaluation by a government-approved physician, and that's to determine whether or not they may have any illnesses that would prevent them from becoming permanent residents in the United States. What's interesting is that up until roughly about 2 or 3 years ago, AIDS was actually a disqualifier for somebody to become a permanent resident, which is kind of interesting given our current situation with coronavirus. So just kind of fast forwarding to the present, what are we dealing with? So in roughly August of 2019, the immigration agency issued revised public charge rules that were anticipated to go into effect, and they've actually been challenged twice all the way up to the US Supreme Court, but the US Supreme Court has effectively put these measures into implementation, and the immigration agency has implemented them into their processes. So that was, well, integrated as of February 24th, 2020. I just want to mention some of the sort of the practical implications of kind of how this impacts your potential clients and which clients it may impact and those that wouldn't. So this rule does not impact, number one, US citizens, people applying for US citizenship or naturalization. It typically does not impact that process. It does not impact current permanent residents. So if somebody's a green card holder now, it does not impact them. Individuals who are VAWA or Violence Against Women Act beneficiaries, it does not impact those individuals. Also excluded from this rule are asylees and refugees. So I mentioned that this has effectively gone into implementation as of February 2020. So what does the rule say? And I'll just give a sort of a quick explanation, and I know Caleb's going to go into much more extensive detail about this. But the question that we're asking is that when somebody is either, number one, extending their immigration status, some sort of visa like an H-1B, L-1, F-1, any of these sorts of visa types, or they're alternatively applying for a green card. The specific term is called an adjustment of status. The adjudicator has the ability to determine whether or not somebody's going to be likely to become a, quote, public charge, somebody who basically utilizes public benefits. So the prior rule before all of this was whether or not the applicant was primarily dependent on public benefits. So that was obviously kind of looking backwards. You would take a look at, well, gosh, you know, did this person and their source of income primarily depend on federal benefits, other than the ones we mentioned earlier, like unemployment benefits or alternatively, Social Security retirement type benefits. So that has now shifted to the analysis of, quote, whether a non-citizen has received or is likely to receive one or more public benefits for more than 12 months in an aggregate period of 3 years. And so just think about it from the standpoint of, gosh, you look at any individual, particularly in the current economic climate, if you could consider, you know, their health conditions, their education, their language fluency, you know, their prior income, their generally career path trajectory, and you are trying to determine, is this person more likely than not to at some point in the future receive public benefits for more than a year? That's a really weird analysis. You are trying to predict something that very few of us can predict. So things that are included in terms of public benefits, so number one, receipt or prior approval of the receipt of anything prior to February 24, 2020 does not generally count. And let's see, for permanent residency, a sufficient affidavit of support will not be outcome determinative as whether or not an individual is likely to become a future public charge is not really dependent on just that affidavit of support. So USCIS is going to consider a complex totality of circumstances test that weighs the alien's age, health, family status, education and skills, assets, resources, and financial status, taking into account a broad range of positive and negative factors. That is extremely broad. I'm going to turn it over to Caleb and let him talk about some of these factors in greater detail.
Roger, thank you so much for that overview. Now I'm going to turn it over to our next speaker, Caleb Stewart. Caleb works at the Rocky Mountain Immigrant Advocacy Network and joined Remain's Anti-Human Trafficking Project in March 2018 after 4+ years of providing civil legal services to survivors of human trafficking with Colorado Legal Services. Prior to studying law and public administration, at the University of Washington in Seattle. He lived in Thailand for 5 years and traveled throughout South and Southeast Asia for another 6 months. He's been a teacher. He's been working on sustainable agriculture, Montessori-based education, and income-generating handicraft projects, and is conversant in Thai, Lao, Spanish, and several pieces of other languages. Welcome, Caleb.
Thank you for that introduction. And so now I'm going to talk a little bit more about the details of the change that happened in February of 2020. We got a great overview of what the public charge looked like prior to this change, and now we'll address how it's changed and how it's affected the analysis. And I'm going to narrow the issue a little bit too, because the public charge can actually relate to several different things. There's a public charge ground of deportability, but that is extremely rare. Roger mentioned how the government can go after a sponsor, saying if the individual used a public benefit, they can go after that money and say you have to repay it. To be subject to a ground of deportability, that has to happen, and then the individual has to refuse to pay it, and then along with several other conditions. And so the ground of deportability hasn't changed, and it's extremely rare. So we're not going to be dealing with grounds of deportability. What that means is individuals that aren't subject to the ground, as Roger said, it like an LPR, who's not subject to the lawful permanent resident, who's not subject to a ground, subject to the ground of public charge, ground of inadmissibility. The only way they're going to have an effect is if they're going to be deported, but the deportability ground is extremely rare, and so they really don't have anything to concern themselves with. I'm also going to narrow the issue to who is adjudicating the visa, because you have the authority for the ground of public charge that comes from the INA 212A4. You also have the equivalent in the US code, and I'll cite that in a second, but it's essentially the same thing, whether it's from the US code or from the Immigrant and Nationality Act. And then from that definition, it gets interpreted by different agencies. And so the Department of State, who's in charge of consular processing, they make their own guides on how to read this statute, and you can look to the Foreign Affairs Manual for that. And so that's for individuals that are living abroad and are wanting to consular process into the United States. A lawful permanent resident, the one time where they might be concerned about the public charge issue is if they leave the country for more than 6 months, because at that point they can be considered re-seeking admission, at which point the public charge can be applicable to them. But that's just if they've left the country for more than 6 months. Then you have the Department of Justice, or these are the immigration courts. And so they sometimes too can adjust people or allow people to change to become a permanent resident while they're in immigration proceedings. And so they're going to be looking at their interpretation of that same statute through the Department of Justice rules and court precedent. But what we're talking about today is the change that was made in February 24, which was a change made by USCIS. And so they're the ones adjudicating these adjustment of status and extensions for non-immigrants. So that rule was changed by the Department of Homeland Security in February 2024. So that's the area that we're going to be focusing on. So in the US Code, it's found at 1182A4, and this is the rule as it's written in statute, which then gets interpreted through those different means that we just mentioned. It doesn't actually define what a public charge is in that statute. And because it doesn't define what a public charge is, that's why it's been open to interpretation in the rules governing the statute. And as Roger mentioned, it used to be that primarily dependent is the way they were defining public charge. Well, that is now changed, where it's going to be individuals, as he mentioned, where they're looking at countable benefits per month. And you have to have 12 months of those in any 36-month period. And I'll get into that a little bit more in a moment. These changes are not retroactive, meaning that any benefits that individuals received before February 2024 won't count in this analysis. So it's benefits that used to be outside the scope of the public charge analysis, but now have been brought into the scope through the changes. If an individual is receiving those prior to February 24, those still do not count as part of the analysis. It's only the things that happened after February 24. It also doesn't count if they receive, like when they're looking back in time to see if an individual received more than 12 of the 12 of these countable benefits when it's in a 36-month period. It's only going back as far as February 24. They can't go back further than that to look at it, whether an individual has received those benefits. As we move further away from this implementation date, then they will have more, the government will have more months to look at. But as it is now, they only have a couple months to look at. So what it does is it redefines, as I mentioned, it redefines from primarily dependent to a public charge being who receives one or more public benefits for more than 12 months in the aggregate within any 36-month period. The tricky thing with that is that you're looking at countable benefits, meaning that within one single month, you can actually accrue more than 1 month for that analysis. Like if you receive, if you're receiving 2 different types of benefits from the state, like cash assistance and some of the new charges, like some of the areas of Medicaid, and you receive them both in the same month, well, that counts as 2 months. And so you can actually accrue more than 1 month within a calendar month because they're looking at countable benefits. So when it changed, they did expand the list to include things that hadn't previously been included. And so they expanded it to include Medicaid. But part of Medicaid is if it's emergency services are not part of a public charge calculation. So if it's emergency Medicaid, that's still fine. That doesn't come part of the calculation. Certain disability services related to education also aren't part of Medicaid, but Medicaid is something new that becomes part of this analysis. Medicare Part D, low-income subsidies, that's a new thing also that becomes part of the analysis after these changes. SNAP or food stamps, food assistance, that is also now considered part of the public charge analysis. But remember, they're only looking back to February. So if an individual is receiving SNAP in January of this year, that doesn't get included. It only gets included after February 24. Section 8 housing vouchers is it's also one of the new categories. Within this analysis, as Roger was mentioning, it's becoming this totality of circumstances test. And so it's a weird situation where they're looking, it's future looking. And so it's looking to see whether you will become a public charge, not whether you have been. Whether you have been becomes part of the analysis, but it is not outcome determinative because they're looking at whether you will in the future. And so you have to look at all the different factors that are considered to see whether the adjudicator thinks that it's likely that you will receive 12 or more countable benefits within a 36-month period. Inside of that calculation for the totality of circumstances calculation, a new thing added to this rule is now heavily weighted categories. And so there are both heavily weighted positive factors and heavily weighted negative factors. And so that's just what they are. They're going to weigh heavier on the scale to tip it whether you are going to be a public charge or are not. There were things that people feared would be changed and would become part of the analysis when they changed this public charge rule that did not. And so I'm just going to mention some things that are not part of the analysis. People were fearful that individuals that are planning to apply to become a permanent resident or adjusting their status, that the benefits received by their U.S. citizen children would affect their public charge status, and it does not. That change was not made. And so individuals that have U.S. citizen children that are eligible for public benefits, those children can continue receiving those benefits without causing any problems for the parents, because the individual must be the named beneficiary on the public charge benefit. Other things that did not happen is people were really concerned about WIC, the women, infants, and children. That is not part of the analysis. The earned income tax credit is not part of the analysis. Subsidized child care, some of the other things on here, disaster relief, energy assistance, all of those things are outside the analysis. Individuals can receive those benefits without any fear of that creating a likelihood of being determined a public charge. As I mentioned, there's heavily weighted factors, negative and positive. And so when the adjudicator determines that you have one of these factors, it's going to heavily weigh in that area to make you a public charge or not. Some factors that are considered heavily weighted negative are individuals that have work authorization but are not working or studying. And home care or taking care of children is considered work. And so if you're an individual with work authorization, but you've been staying home full time to take care of children, that is not counted against you. That is considered employment. Another heavily weighted negative factor is that you did receive or were certified to receive one of those countable benefits. So like whether it was SNAP or Medicaid or Section 8 housing, you received those in the past in the aggregate of 12 in a 36-month period. But remember, they're only looking back to February 24. And so those are just starting to pile up from February 24. That's as far back as they can look right now. But once we get 3 years out from February 24, they'll be looking back 3 years to see that if an individual has received those. And so if you've just received one for 1 or 2 months, that's not going to be outcome determinative for your public charge rule. They're looking at if you've received 12 of those countable benefits within a 36-month period. And even then, that's not going to say that you're automatically going to be determined a public charge. That just becomes a heavily weighted negative factor. But let's say you have a heavily weighted positive factor that could counterbalance the negative factor you just had. Other heavily weighted negative factors are health conditions, with serious health conditions, but no private insurance. So an individual that has some serious health condition, but doesn't have a way to pay for that with private health insurance, that's considered a heavily weighted negative factor. If you were previously found inadmissible on public charge grounds, that's a heavily weighted negative factor. But you can outweigh some of these things with positive or heavily weighted positive factors. If your household income or assets or resources or support you receive is above 250% of the federal poverty guidelines, that's a heavily weighted positive factor. So let's say you're an individual that was out of a job for a long period. And so you did receive those benefits and you had 12 countable benefits in a 36-month period. That's a heavily weighted negative factor. But now you've been able to get a great job. Your job now allows you to earn 300% of the poverty guidelines. You can still show, even though you had received public benefits in the past, you can still show you're not likely to meet this definite public charge, meaning to receive 12 or more benefits in a 36-month period in the future, because you now have this positive, heavily weighted positive factor of a high income earning job. The employment with an annual income that exceeds 250% is above the federally poverty guidelines is also a heavily weighted positive factor. And if you have private health insurance, unsubsidized, that's a heavily weighted positive factor. If you have a subsidized form of healthcare, that's still a positive. It's just not a heavily weighted positive. So if you're receiving subsidies through Obamacare or something, that won't be considered heavily weighted positive. It'll just be positive. And so there's 2 tests that we're going to be looking at. There's a test for non-immigrants that are looking to extend their stay or change their status. And then there's a test for lawful permanent residents, applying to become a lawful permanent resident or adjusting your status. So if you're a non-immigrant and you're looking to extend, you must disclose whether you have received or are certified to receive certain public benefits on or after February 24th. There's a form that you have to fill out to provide during that application process, the I-129 and the form I-539. In this test, what they're going to be looking at is they're looking at whether you have received those 12 countable benefits in a 36-month period. As I mentioned earlier, 1 month of benefits equals 1 benefit per month. So you can receive 2 benefits in a month, and that counts as 2. If the answer to that question is yes, then you fail the public charge determination as a non-immigrant extending their stay, and you will not be granted that extension. If your answer is no, then you pass the public charge determination, and that's it. So that's the case when you're just as a non-immigrant looking to extend their stay. But for green card applicants, so individuals that are applying to be a lawful permanent resident, the test is this totality of circumstances test. And so it's going to be looking at those same countable benefits, but it's also going to be looking at all these other factors to see, once we've analyzed all the factors, is it likely that in the future they will become a public charge based on this new definition. No one factor is outcome determinative, because as I mentioned, if you've received, even if you've received 12 countable benefits, 12 of those like SNAP for 12 months, that doesn't automatically disqualify you. They're still going to be looking at all the factors in your situation. In this test, as Roger mentioned, they are looking at age, health, family status, prospective immigration status, assets, education and skills, and the affidavit of support. In the past, the affidavit of support was basically all you needed. If you didn't have enough income, you'll get a sponsor that does have enough financial resources. They sign the affidavit of support, and that overcomes any public charge ground. Now that affidavit of support is just one part of the total analysis. It doesn't allow you to overcome the public charge determination in and of itself. Some things that also are going to be new and also are very ambiguous on how they're going to be adjudicated is like under education and skills, language is now a test. And so if you don't speak English, they can count that against you in a public charge test, considering that to mean that it's harder for you to find work. And so language skills, but there's no determination about how they're going to grade one's English language ability. And so that's a very ambiguous area for them to be looking at when they're looking at whether you're going to be a public charge. Age, if you're within what they consider working age, like 18 to, I don't remember the exact age, 65, or I don't remember, don't quote me on the age, but there's the mid-range is where you're not considered a negative, it's considered a positive, but if you're young or old, they'll consider that a negative in the calculation for this public charge calculation. Within some changes or some concerns within the situation right now with COVID-19, some things that you don't have to be concerned about is emergency Medicaid. So even though Medicaid is now part of the calculation, emergency care still is not part of the public charge calculation. So if you need to receive emergency Medicaid, it's still not going to be considered in a public charge test. USCIS has announced that testing, prevention, or treatment for COVID will not be used against immigrants in a public charge test. So immigrant families should go and seek the care they need. It's not going to be part of the calculation. Unemployment eligibility is state specific, and so many individuals aren't going to be eligible, but in some states they are, like in Colorado, somebody without status can potentially still be, or non-citizen can still potentially be eligible for unemployment status. And if they do receive it, that's not part of the calculation. It's considered an earned benefit. The recovery rebate is considered general assistance, or it's not general assistance, it's a tax credit. And so that also doesn't factor into the public charge calculation. Pandemic EBT is also not part of the calculation. And so those are things that individuals can continue to use without concern. As mentioned, there's still ongoing litigation. For a while, the new rule was stayed, and then it wasn't, and then that stay was lifted. Right now, this litigation is still ongoing in all of these different locations. So there's about 9 different cases that are still active. And so it's still possible that this new rule will be overturned eventually. And if it is overturned, it'll go back to the calculation of looking for someone who, the calculation that Roger discussed in his presentation before the changes, meaning the 12 countable benefits in a 36-month period. So it'll go back to likely to become primarily dependent upon public benefits. So that's the changes that I had to discuss. And so now I will pass it on to Harry to discuss kind of how this is affecting certain populations.
Thanks, Caleb. Our next speaker, Harry Garza, is the Executive Director of the Asia Pacific Development Center. Harry received his BA in Political Science from California State University in Los Angeles, his Juris Doctorate from University of Colorado Law School. He is the Executive Director of APDC and works with government officials and community partners to address health disparities in the immigrant and refugee communities. Harry's going to give us an overview of how this new rule is impacting a community health provider. Harry?
Thank you, Nicole. And hi, everybody. As Nicole mentioned, I am the Executive Director of Asian Pacific Development Center, and I am here to talk. We provide a lot of services for the immigrants and the refugee community. So I am here to talk about the impact of the public charge rules on the community and basically the fear and the chilling effect that we have seen in the community. So as Roger and Caleb mentioned, this rule did not become active until a few months ago because of the litigation. However, the fear in the community has started all the way back since 2017. If you Google public charge rule, you will find news article as early as 2017 talking about how a lot of immigrants and refugees are afraid of enrolling in public benefits because of public charge. So in this slide, you see the national data that we have. This is the best survey that we were able to find. It's from 2018, so it's about 2 years ago. But you can see that the impact, the fear is spread throughout the community. So almost 14% of adults in immigrant families reported that they did not want to enroll in any public benefit program. And we also see that chilling effects, it's also happening to people that are specifically exempted from the public charge rule. So people that already have legal permanent residence and people that are already US citizens, you can see that there's 15% of LPR afraid of enrolling and almost 10% of US citizens afraid of enrolling. So this is definitely something that we see on a national scale. Next slide, please, Nicole. And here is the data from Colorado. So a similar survey from the Mile High Health Alliance from March 2018, they surveyed the safety net clinics in the Denver metro area. And pretty much all of the safety net clinics, so we're talking about Denver Health, Clinica Tepeyac, Salud, and other clinics have reported an average of 17% decline in refugees and immigrants seeking health care, 19% increase in people failing to show for their appointments and cancellation, and then 20% increase among Denver Health clients that have refused to enroll in government benefits. This is definitely not an isolated incident to Denver Health. At APDC, we have had clients that specifically have told us that they want to withdraw from Medicaid, from food stamp, and from other public benefits because they're afraid of how it impacts their immigration status. And then you see the latest data from Colorado Medicaid office that in Colorado, particularly, that the enrollment decline in Medicaid and children's health insurance is 3 times the national average. We don't quite know exactly which factors contribute to this because when people decline to enroll, they don't exactly fill out a survey saying why they're doing it. But if you talk to anybody from the Medicaid office, they will acknowledge that the fear on public charge is definitely one of the primary reasons why we're seeing this decline. Next slide, please, Nicole. Yeah, so that is the impact that we're seeing in the community. This is definitely a very serious concern. We have a lot of immigrants and refugees that are afraid of seeking healthcare. And as Caleb pointed out, a lot of the services to help you with COVID-19 are exempted from public charge, but we still have clients that are asking us questions about whether or not they can seek healthcare, how will this impact their immigration status, whether or not this will get them to be deported. And as an immigrant myself, I can understand that fear because when you are not a lawyer, especially if you're not an immigration lawyer, you don't fully understand how immigration law works. So this is definitely an impact in our community. And I'm happy to answer any questions regarding impacts and how our community is dealing with the public charge rule.
Thank you so much, Harry. We have a few minutes to answer some questions for our speakers. If you would like to put it in the chat box, we can go ahead and read those off and share with the rest of the participants. I can kick us off with the first question, then maybe Caleb or Roger can take a stab at the first question. So do lawful permanent residents need to be concerned about public charge regarding their travel or extended stays outside of the country?
So lawful permanent residents aren't subjected to the grounds of public charge unless they are seeking admission, meaning that they've left the country for more than 6 months and now are trying to process back into the country. As long as a lawful permanent resident is staying in the United States and not leaving, then the public charge ground is not applicable to them and they don't have concerns. There is that ground of deportability, but again, that is extremely rare. And so so generally speaking, a lawful permanent resident does not need to be concerned with the public grounds of public charge.
And I would just add that that 6-month marker, there's a rationale to that 6-month mark. I mean, in the main, right, once you're a permanent resident, you are permanently a permanent resident. Those permanent resident card or green cards last for a 10-year period of time. But the idea is that your long-term intention is to remain in the United States. And when you leave the United States for a 6-month continuous period, there's the implication that you may have, quote, abandoned your permanent residency. So effectively abandoned the United States as your place of residency. There are ways in which you can, number one, either put the immigration agency on advance notice that, hey, I've got a 2-year work stint in Japan and that's the reason why I'm leaving. I'm not seeking to abandon my permanent residency. So there are ways in which you can provide that sort of affirmative notice to the government so that this does not become a question as to whether or not you abandon your permanent residency. And then number two, there are ways in which you can factually preserve your residency in the United States, continuing to maintain your financial accounts here, your retirement accounts, any sort of leases, any family members that may remain in the United States. Those are all factors in which that would be considered in maintaining your residency in the United States.
Thank you. Our next question is in relation to COVID-19 relief funds. Will small business owners who are undocumented have immigration ramifications if they apply for business relief funding?
So Caleb, my sense is that you already responded to this. Effectively, most of those grants are effectively loans. Those are not, they're being given to an entity rather than a particular individual. I don't know if you care to add on further.
No, I think those are they're considered either loans or they're considered tax credits or they're just considered earned benefits, and all of those won't be part of calculations. And so some of these, and then also emergency things aren't part of the calculations. And so these business, through a few calculations, is the benefit has to be in that person's name. It's not an emergency situation, and it's also not one of those tax credits or earned benefits, and these are going to be considered earned benefits or tax credits, and so it wouldn't be part of that calculation.
Okay, our next question is, if an adult child receives SSI benefits and she assists her parents in seeking citizenship, would this hinder the parents in receiving citizenship?
And so when one individual, you're calculating the public charge of the individual, like, well, for one, at citizenship level, the public charge is not part of a citizenship calculation. And so no, it doesn't affect the citizenship. When you're seeking citizenship, there's no public charge calculation. If early in the process, an individual, sometimes you're concerned about whether the sponsor, if they've received benefits, whether that's going to be an issue for their family member that they are applying for. Again, when you're doing the calculation or analysis for public charge, it's just the person that's seeking that lawful permanent resident status, not the sponsor. So the public charge isn't going to be applicable to that sponsor. However, if that sponsor was eligible to receive a public benefit, that probably means that their income was low. And if their income was low, that is an issue for them becoming a sponsor, because they are looking at whether that sponsor has sufficient income. And so specifically having received those public benefits, the sponsor isn't part of the calculation, but by virtue of being eligible for those benefits, the sponsor is probably of low income. And so that could be an issue as the sponsor applies for a family member.
Thank you. And our guest did apologize. It was a green card they were referring to, so thank you for clarifying that. Our next question is about discretion. So in reality, it's up to the counselor/officer, or in this case, the DHS representative that would be making decisions. Can you all talk a little bit about the level of bias that might be involved? So it's our guest asked, if it's up to one person, isn't that a bit of bias? So maybe both of you can talk a little bit about discretion.
So just to be clear, yes, there is a bit of discretion, right? So the sort of the weighing of evidence is essentially, is it more likely than not that this person will become a public charge in the future? And that analysis only pertains to the adjustment of status green card process. It does not apply to extensions or changes of status. If somebody's going from, let's say, an F1 international student to an H1B, that sort of discretion does not apply. It only looks at whether or not a person has had 1 year out of the last 3 years of public benefits. But going to that sort of idea of discretion, you're right to some extent. You know, these sort of decisions will be made by individual adjudicators within a U.S. Citizenship and Immigration Service office. It could also be made by a consular officer abroad, as you suggest, although those are a much smaller minority of cases, because most applicants who are applying for green card status are in the U.S. I think a question, right, and we have yet to kind of see how this will fully play out, is, are we going to see instances where somebody's applying for permanent residency and they show up at that office and they're being interviewed, and they let's say they don't speak any English. Let's say they're 65 years old and it's really kind of too late for them to learn English. That adjudicator is trying to communicate with them, and they're really not able to get any factual details out. Well, gosh, you know, is that an instance where that adjudicator, in their totality of circumstances consideration, may choose to decide, yeah, this person, how can they get a job? They can't speak English. What sort of labor can they do? So I think it could arise. I think one factor that we haven't talked about, and this is once again at the discretion of USCIS, is there is the concept within the regulations of a bond. So similar to kind of like I guess a criminal bond, where somebody's released that has criminal charges but is still undergoing trial, they could essentially place a financial bond, a monetary bond, that would allow them to be outside of incarceration, but still be considered, but still have their freedom. The idea of a financial bond would be, and this hasn't really been fleshed out fully, but maybe it's a bond of $5,000, $10,000, and over the course of the next few years, as long as the person doesn't begin to utilize federal benefits, they would effectively be given that money back. So anyways, there is the potential of a bond being sort of part of this process if somebody is not able to show that they will not become a public charge. And so it may be an alternative. I would say in every instance in which somebody is being denied a benefit, typically a USCIS adjudicator has to run that past a supervisor. So there's one layer of sort of analysis. On a practical level, typically most adjudicators will give individual applicants an opportunity to present any sort of evidence, either individually or through their attorney, that might have bearing on some of these issues. So there's always those sort of alternative avenues. Caleb, I don't know if you have additional thoughts there.
Yeah, there's just so many parts of this calculation that are pretty subjective. And so I think there is a lot of space for discrimination in with the adjudicator that you just happen to have on your day. because a lot of these rules were written to kind of balance a fine line where there can't be discrimination based on language ability, and there can't be discrimination based on age, but you can use those as part of your calculation to decide whether the person is likely to get work. And so the way the rule was written, it was to try to keep them within the framework of saying, no, we're only looking about their language ability so that we can determine whether they're likely to get a job or not. We don't really care if they can speak or not. It's just part of whether they can get a job or not. So it was they wrote the law to try to get around having charges of discrimination, but I expect that there will be litigation around those areas saying that no, as much as you tried to say the law wasn't going to be ageist and the law wasn't going to discriminate based on language and other things, it does. And so I expect that there will be litigation over some of these areas that just seem to have too much room for discretion. For bonds have always been part of something that's been available but rarely ever used. And then when the new rule was written, they talked about the bonds quite a bit, as if with the kind of the expectation that they would start issuing these financial bonds more often. I think they do start at like $8,100 and then they go up from there.
Thank you, Caleb. Our last question is, how would a disability such as being deaf factor in if the individual could work so long as auxiliary aids and services under the ADA were provided? And I guess the assumption would be that that person would be applying for a green card because it would be pertinent to them in that instance.
And so I think that's another great example of where I kind of would expect that we potentially could see litigation, because I imagine it's going to be looked at as another factor of making it difficult for them to get employment unless they can show other ways where they are going to have employment, or maybe they already have a job. Then it wouldn't become part of it if they can show they're already employed and they're going to continue to be employed. But it could be part of the analysis of looking at whether this person is likely to be employed.
Thank you. And that concludes the questions for today's presentation. I'd like to send it back to our speakers to wrap up any final thoughts as we close out our presentation for today. So I'll send it over to you, Roger, to kick us off. Any closing thoughts?
Sure. Just to wrap up, I mean, I think as you are going through this sort of process with your clients, once again, think through kind of their immigration status. You may, as part of your intake questionnaire, may want to start asking about immigration status, just so that you have awareness. I recognize a lot of the time, some clients may not even know their immigration status, and you may kind of need to help them through that analysis. We've talked about a couple of different concepts: permanent residency, so green card status, and those that have a temporary visa, H-1Bs, L-1s, TNs, you know, the alphabet soup of short-term visas. You know, we have not discussed, you know, those individuals who might be under DACA status, those who have sort of the two-year work permits based on an executive order that President Obama had issued several years ago, or those who are undocumented. In short, many of those folks probably don't have too many great viable immigration options. And in short, you know, even the ability to get a green card may be years, if not decades away from them. So anyways, the analysis of obviously one, whether or not they have sort of an immigration issue because they're not a US citizen. Number two, whether or not they are going to take on any sort of federal benefits or federal state benefits that would qualify as a potential public charge. This is pretty complex, right? And I'm not somebody who deals in this world regularly, but if I were an immigrant individual who did not necessarily was savvy in sort of navigating a lot of these benefits, and essentially I'm hearing, well, you know, emergency Social Security benefits are okay, but not SSI. TAMF is not okay, but you know, food stamps are not either. It is a bit confusing, and obviously it's a potential landmine. I guess anyways, I would point them to USCIS's sort of guidance in terms of what sort of benefits are available or not. The American Immigration Lawyers has also circulated some documents in case those of you might want to get additional details on some of these components. no doubt that essentially what Caleb had mentioned, this is in flux. This may be changing. So, you know, I think it's worthwhile to pay attention to see if this changes in about a year.
Thank you so much, Roger. Caleb?
My final words would just be that the sliver of people that are actually affected by this public charge change is actually fairly small. There's the pocket of people that have public charge applicable to them, meaning it's those applying to adjust status or those applying to extend status. And then there's the pocket of people that actually are eligible to receive benefits. And eligibility for benefits hasn't changed. And the vast, vast majority of individuals that are eligible to receive benefits are eligible because they are lawful permanent resident and have been a permanent resident for 5 years already, or they're an asylee, or they're a refugee, or they're a victim of trafficking, or they have a U visa. In all of those categories, the public charge rule doesn't apply to them. And so the number of people that actually are eligible for a benefit and public charge is a concern for them is pretty small. And so I think the takeaway should be that most people shouldn't be concerned by this change, and they should continue to use the benefits that they're eligible for to help their families be safe and secure and healthy.
Great, thank you. And Harry?
And I want to echo what Caleb just said. And yes, I mean, we are encouraging people to continue using their benefits in consultation with their immigration attorney to make sure that they are safe and they're okay. But the fear is there, the fear is real. And, you know, I am grateful that we have a lot of good advocacy organizations that are actively advocating to modify this rule. So we are hoping that there will be more positive changes coming in the future.
Excellent. Thank you so much to our speakers. I'd also like to recognize Sue Kim from the Asian Pacific American Bar Association, who helped us in planning this agenda for today's webinar. If you'd like to learn more, you can certainly visit coalition.centerforhealthprogress.org. This presentation will be available there via video, as well as some of the handouts in English and Spanish on public charge that the organization has recently uploaded to share with the broader community for informational purposes. For those of you taking today's webinar for CLE credit, we will be circulating the affidavit from the Attorney General's office to you, as well as an evaluation, and then you can go ahead and submit that at your convenience. Credit will only be available for the folks that attended live webinar today. We simply can't follow up with everybody as we would like to on an ongoing basis. So those of you that attended today, thank you so very much. Thank you again to our speakers, and thank you for joining us today. Stay well and be well, and have a wonderful rest of your day.
Thank you all.
Thank you.
Thank you.